14C, rescind city council decision concerning the circular driveway at 1231 San Carlos Road.
Thank you, Madam Mayor. This is your final evening, or your final item of the evening, as you say, to rescind city council decision concerning a circular driveway at 1231 San Carlos Road, per the decision in the case of Tom Crosby et al. Versus the City of Arcadia et al. Superior Court, case number BS 172105. We would recommend that you rescind your previous action and then provide additional direction at that point. I'll turn it over to Jason.
Okay, thanks very much. We've talked a little bit about this this case tonight, or heard some comments about it. Back on October 17th of 2017, the City Council held a hearing to consider an appeal related to the denial of a circular driveway at 1231 San Carlos Road. The appellant was the Santa Anita Oaks Homeowners Association, and they were appealing the Planning Commission's decision, there's a lot of steps with this one, to approve the plans for the circular driveway. So originally it had been denied by the Homeowners Association Architectural Review Board chair, and then the homeowner had appealed it to the Planning Commission. Planning Commission had overturned the original decision. That decision was appealed and came in front of the council, so a number of steps. From the council decision, the case was taken into court, and a writ of mandate was sought against the city. The Superior Court did decide on this case. They directed that the City Council's October 17th decision be set aside and rescinded, as was mentioned. It was important to note, however, that the court's decision leaves open how the city chooses to further consider this matter, if it chooses to further consider this matter. The conclusion of the ruling states that, quote, the court will remand the matter for further proceedings consistent with the court's decision, and that leaves the City Council with several options, and I'll just briefly talk through them. One option that the city has is to rescind the original decision and then take no further action. And what the effect of that would be is that the Planning Commission's decision to approve the project would stand. There are a couple different ways that could be done. One is that that decision would stand and there would be an appeal period, as is laid out in the municipal code, of 10 days for anyone to appeal the decision, or that action could also include the council accepting the Planning Commission's decision as its own, and in that case there would be no appeal possible. So let's call that 1 and 1A. Another option would be to rescind the original decision and to hold a new City Council public hearing on the matter. That's another option. The City Council could then hold further proceedings, and as the court stated, they need to be consistent with the court's decision, and sufficient findings would need to be made in support of the direction and the decision based on the design review criteria that's in the City Council Resolution 6770, which governs homeowners association design projects. Another option would be to rescind the decision. Obviously, that's the constant in all of these options, and remand the matter back to the ARB, the Architectural Review Board, for its determination. And again, similar to what I just mentioned with additional proceedings at the City Council level, if it went back to the ARB, the Architectural Review Board, the ARB would also not be able to rely in any way on its earlier circular driveway policy, but also would have to make sufficient findings in support of their decision and facts to support those findings. So again, as Mr. Lazaretto mentioned, it is recommended that the City Council rescind the October 17th, 2017 decision on the matter pursuant to the court order, and then further recommended that the Council provide additional direction on how to conduct further proceedings. And with that, we're certainly available for any questions, as is Mr. Deitch.
So I'm going to start off really quick that I just realized we do have a fourth option that is not here that for some reason didn't get considered and didn't get brought up earlier. We could appeal this decision. Is that right?
You can do that.
So we could appeal to the state appellate level. So there are still several layers of appeals that could occur after this. So that would be a fourth option that this City Council could consider, in my own legal opinion. Sorry, I wasn't there.
Madam Mayor, in your legal opinion, why in the world would we appeal to the appellate court?
Because the decision by the judge is entirely a almost biased personal, her feelings in regards to the findings that we did. You get another judge, you'll have a different decision, definitely, because the opinion was mainly directed at the lack of specific facts and findings adopted by city council at the hearing. That's where she got stuck and got tripped up on whether or not we whether or not we used proper discretion in denying the driveway. So it wasn't a matter of we couldn't or we abused our discretion. It was a matter of she couldn't tell what we had done because she didn't like the way that we made the motion and approved or denied the circle drive, the driveway.
Well, we were all there at that hearing, and quite frankly, Mr. Vargas did not provide any findings to this city council, as far as I was concerned, any facts or findings. In my opinion, and I think the judges shared it, his decisions were capricious and arbitrary. There was no precedent for what he had done. As a matter of fact, all of the rules and the previous city permits and the existence of an abundance of circular driveways were present. In addition, he was not able to provide minutes that weren't post-dated. And quite frankly, Mr. Vargas has run up the bill on us many, many other times for his arbitrary and capricious decisions. And I have personally experienced this since being on this council for a long, long time. Many of these homeowner associations operate perfectly fine. They save the city a lot of time with their review process. But this particular individual, since he's taken over, has cost the city a lot of money, and I don't want to get into any more money. And we can't depend on his findings or lack of findings to provide our lack of findings. We'll be in the same boat as him, making up stuff.
Okay. All right. Yes, yes. So,
Comment.
thank you. So we did have a couple of speakers, but I wanted to make sure before we went to speakers, did any of council have any other questions or items? I just wanted to bring up the fourth option before we went to speakers.
Speakers that spoke about Crosby, speak about Crosby again?
No, it'll be, if you've already spoken, if somebody from the public has already spoken to the Crosby matter during the public comment period, they will not be allowed to speak at this time. However, we do have two speaker cards that identified item 14C, so we reserved their speaker cards to have them come and comment now. If we don't have any other questions, I'll go ahead and ask that they come up and speak. Okay? Jean?
Okay, our first one is Mr. Alexander Janvelian.
Thank you, council members, city staff. Thank you, Mr. Deutsch, for allowing me to speak with the city council. As you know, my firm represents the Crosbys in the administrative mandate case that we won against the city. We're here to discuss this administrative mandate issuance, and first I want to start with the staff report, which grossly mischaracterizes the decision. The staff report states that Judge Mary Strobel issued a decision that in part granted the petitioner's writ. That is entirely incorrect. The decision was granted in full and not in part, and the conclusion section of the court's statement of decision does not make any indications whatsoever about a partial grant of the petition. Second, the staff report points out that the court found in favor of the city on a number of counts. While technically correct, it is also true that the court did not have to examine many of the Crosby's arguments because the city, and I'm quoting here, unconstitutionally delegated authority to the ARB to enact land use regulations, failed to proceed as required by law, and prejudicially abused its discretion. For instance, the court did not have to examine whether the city improperly delegated authority to administer the design guidelines. The court also didn't have to examine whether the Crosbys were afforded a fair hearing. In other words, the court clearly saw that the city abused its discretion and did not need to address the other arguments made by the Crosbys. Third, the staff report's fiscal impact section is entirely deficient because it fails to inform the citizens of Arcadia that the Crosbys shall be filing a motion to recover their attorney's fees unnecessarily incurred as a result of the city's gross abuse of discretion. The statement of decision supports several discretionary bases for recovery of attorney's fees, and if the court awards Crosby's all or part of their attorney's fees, Arcadia citizens will have to shoulder this financial burden. Now let me get into the options proposed by the city staff. The first option talks about the reinstatement of the Planning Commission's decision, or in the alternative, making it a new decision and providing another 10-day appeal period to the Santa Anita Oaks HOA. There's nothing in the Arcadia Municipal Code which creates a second, new 10-day appeal period after a city decision is set aside. The staff report offers zero authority in support of its position that the Planning Commission's August 22nd decision is a new decision. Yes, there's a 10-day period under the municipal code, but just because this 10-day period is created doesn't mean that Santa Anita Oaks and Mr. Vargas get to appeal the planning decision twice. The city should reinstate the August 22nd decision and not afford the ARB another bite at the apple. If it affords the ARB another chance to appeal, the petitioners are prepared to go back to court and inform the court accordingly. The second option proposes scheduling a new city council public hearing. While you're well within your right to do that, any new hearing must contain sufficient findings and must respect the court's mandates. If the city tries to come up with some post hoc rationalizations in support of another denial, the Crosbys will again go back to the court and inform the court of this. The neighborhood-specific standards were found to be invalid, and of course the Crosbys reject the city's implied contention that the single-family residential design guidelines can be interpreted to override the municipal code. The municipal code expressly prohibits this. Thus, the city has absolutely no basis to deny the Crosbys' right to a circular driveway under the municipal code. The third option talks about remanding to the ARB. This is a non-starter. Although the city has discretion to hold future hearings, the city has not set forth any authority in support of the notion that the ARB gets to review this twice. And considering the ARB's belligerent insistence on the use of the neighborhood-specific standards that were not validly adopted, this ARB should not be afforded another opportunity to review the Crosby's matter. Again, any post hoc rationalizations will be vigorously fought in court. In light of all this, let me just raise the fourth option. Appealing this decision would be foolish in my opinion, and we can disagree about this, but the court is going to look at all of the arguments that it didn't analyze, and I'm talking about the Court of Appeal is going to look at the arguments not analyzed by the trial court, and it's going to sink the city into a deeper hole. In light of the foregoing, the city should rescind its October 17, 2017 decision, set it aside, and reinstate the Planning Commission's August 22, 2017 decision with no opportunity to appeal for the ARB and no new hearing for the city. If the city does not act in this way, the Crosbys will continue exercising all of the rights and remedies available to them under the law and the judgment that was entered in their favor. Thank you.
Our next and last speaker is Charles Chan.
My name is Charles. I live on Gloria Street in the Santa Anita Oaks area. Tonight I'm speaking in support of my friends and neighbor Tom Crosby and Ellen Fu, who have recently won a hard-fought legal battle against the city in a request to build a circular driveway on the property. Tom and Ellen had their property rights taken away when the Santa Anita Oaks ARB unjustly denied their plans for a circular driveway and when the city council improperly upheld that decision. Luckily, the judge in the case sided with Tom and Ellen against the city. I too had my circular driveway denied in 2015 by the very same ARB. The process was completely arbitrary. It was vaguely communicated that circular driveways were banned because it did not conform to the neighborhood standards, even though the majority of the houses in the neighborhood actually had circular driveways to begin with. Unlike Tom, however, I did not pursue the matter for fear of any further delays. It is now clear that the ARB had overstepped its boundaries. Today's staff report clearly states, and I'm quoting, "The court found that the ARB had improperly usurped the city council's role by adopting a blanket prohibition against circular driveways for new homes." So even though Tom's driveway followed all the proper city codes, it was still denied because the ARB misused its power. And because of this, how many homeowners' property rights were taken away throughout the past 7 years when the supposed circular driveway ban was in place? What was even more egregious to me was the city council's handling of the matter when council members Beck, Verlado, and Amundsen voted 3-2 to deny Tom Circular driveway. The judge in the case clearly states the failure of the city council to review the neighborhood standards until after it rendered its decision is troubling. Even the judge finds it troubling that the city council failed to review the legitimacy of the ban on circular driveways before it hastily sided with the ARB. The judge goes on to state, the city's attorney encouraged the council to address findings. Despite that request, the majority did not set forth findings that reflect the decision of the body. So against the city's own attorney's advice, the majority of the council did not even address any evidence before denying the circular driveway. So in summary, the majority of the city council members that voted 3-2 to uphold the ARB decision did so without even reviewing the neighborhood standards, and it did so without even addressing any findings in support of that decision. The city council's mishandling of the matter left Tom no choice but to sue the city to restore his property rights. But it is us, the taxpayer, that have to bear that legal cost when the ARB misuses its power and when the city fails to carry out its due diligence. Council members, I urge you not to repeat the same mistakes and cost the taxpayer any further legal costs, especially when the city is supposedly facing a budget deficit. Rescind the original decision to ban the circular driveway, uphold our property rights, do not waste any more of our tax money, and let this family build their circular driveway. Thank you.
Well, that wasn't the last speaker. We have one more last speaker, Edmund Liu.
Good evening. Thank you, Mayor Verlado, for giving me the chance to speak. And good evening, councils and city staffs. So it doesn't matter what option that you folks is going to pick, but that's except one, which is to continue to waste the taxpayers' money on a case that the city already lost. So the judge already made the decision or make the direction saying that it's not the way that it should be for the vote that happened to against the circular driveway. So we just passed Measure A, and a lot of people put in a yes vote because they believe the money that they put in, that the extra money that they have to pay, is for a reasonable city service to maintain the same level of the service. So please do not betray their trust, and they're counting on you guys to spend the money wisely, and please make your wise decision. Thank you.
That concludes the speakers.
Thank you. All right. Then returning to City Council, do we have any other comments or discussion?
Well, there's two parts to this. First, I think we've all read the judge's decision, and the court directed the city to set aside the administrative decision. And I think I'm in favor of that we should set aside that. And then the second question is, what do we do? Mr. Crosby's attorney said that it's, quote, well within our right to schedule a new hearing. And he was critical of some of the other options we have. So I think the safe route is to schedule a new hearing. I don't think it's fair to Mr. Crosby to send it to the ARB because that is going to take a long time to work its way up. And if Mr. Crosby isn't happy, that it'll get appealed, and then it'll be an additional amount of time at the Planning Commission. Somebody's not going to be happy, and it'll get appealed back to the City Council. So I think we should keep it here and not send it anywhere else. And I agree with Mr. Crosby's attorney that it's well within our right to schedule a new hearing, and I think we should schedule a new hearing, and hopefully as soon as possible so that we can resolve this once and for all.
And any other discussion?
Right. Well, I have the opposite view. I do not think we should schedule a new hearing. I think the judge indicated we muffed our portion of the first hearing we had, and quite frankly, I think we should rescind the findings of our hearing and adopt the findings and the decision of the Planning Commission. And also, I have a question for our city attorney. What control do we have over these ARBs, specifically Mr. Vargas? I have issues with Mr. Vargas and his, over the years, I have experienced requests for aerial views of sites, models of homes, which cost like $5,000 to build, rear yard landscape plans, not allowing balconies or even fake balconies. Now this reduction of hardscape, which ultimately ended up with this ruse, as a ruse to this not allowing circular driveways. So personally, Mr. Vargas is a problem, and I don't want to be spending...
I'm going to go ahead and stop you there. Listen,
Yeah, well,
with all due
yeah,
respect,
I'm
listen,
asking the
I know,
city attorney
I
a
know,
question.
but
So
with all
what
due
control do we have
respect,
over here?
that's not on the agenda for tonight. So what I'm going to ask is that we stick to the agenda for tonight.
10-4, is that within our realm of discussion?
That's not on the agenda.
It's too broad a question. It's
broad?
It is, and it can be a subject for a future agenda, but not this item, not tonight.
Okay, I would like to ask for 3 votes, to
You're one.
discuss that
You
at
can
a
be one.
future time, because I think it's a significant issue. And it doesn't happen very often, but it's happened too often there.
And I believe we're going to be discussing Resolution 6770 and,
Yeah, that's what we were conferring on. So the city staff is in the process of bringing forward updated design guidelines, which includes an update to Resolution 6770, which includes an update to, which a clarification of the roles and responsibilities of all of our architectural review boards, provides a lot more clarification to the powers they have and don't have, et cetera, et cetera. That's working its way through the public scoping process. We expect a planning commission hearing around,
Late July at this point.
and then up to the city council a month or so thereafter. So if you do nothing, you'll have this conversation anyway by the end of this summer.
Okay?
okay, so I'm not trying to cut you off.
I
and-
got you, you did a good job.
You got your wish, it's coming up.
Yes, it is on the agenda in a
Well,
future.
Well, I do have one comment. The last time we had a 6770 hearing, it was held in that little room over there, and that was jam-packed with people, mostly from the homeowner associations, and it turned into a shouting match, and a whole bunch of decisions were made on the fly, and none of this addressed some of the real issues, and the real issues being that nobody wanted to stick up for property rights
Okay.
because of the yelling and shouting of a
Okay.
one-sided audience.
It's
Roger.
really not for tonight. You got your comment in, but the agenda item is coming up in the future.
You'll have plenty of time to
Thank you, Madam.
rant and rave about it, okay? But just
Can I
not
have
tonight.
one more second of latitude? Just
1 second.
The public comment, the document is available for review and inspection, and we hope the public reviews it, comments on it, and gives us all their input, so the council knows beforehand what folks think about it.
Well, I don't know if, Tom made a motion, correct? Or did you make a motion or a
No.
recommendation?
No,
Comment.
comment.
Would you
So,
want me to make a
but,
motion?
No, I
no,
don't. Well,
No.
we're going to have, okay.
there
then-
might be somebody else who'd like to talk.
All right, then.
Okay. Anybody on this side?
Well, I spoke.
Okay.
Unfortunately,
Councilman.
the show doesn't have a voice tonight.
Joe saved his voice for this
I
moment.
want to say something.
Oh, yes.
The ARP, Vince Vargas did that to Tom Crosby. And earlier, I think Charles, right? He was asking for circular driveway. He got denied, right? So now you have 2 victims here. So if you go to appeal to the court, then they can get more victims. Then we'll be in trouble. So there's no sense of wasting money. The city and money for the attorney, because now there are more victims out there. Say, I asked for circular driveway, they will not give it to me. Right, so we got to think about that.
Councilmember Edmondson. Anything?
I think I've said what I'm saying.
Okay, thank you. I just wanted to go ahead and read a quote as well from the judge's opinion. Petitioners contend that no substantial evidence supports a determination to deny their proposed circular driveway pursuant to city's general plan design guidelines, Resolution 6770, and other municipal law. Because City Council did not issue Topanga findings, and City improperly relied on ARB's neighborhood standard regarding circular driveways, the court does not reach petitioners' substantial evidence arguments. So what the judge is saying is because we didn't do what's called Topanga findings, which is a case that describes how council is supposed to conduct their hearings and issue findings based on facts. Although some attorneys might opine that we did issue Topanga findings and that they should satisfy the Topanga case, I gave several facts at the hearing as to support the findings and the conclusions that I was making, irrespective of what the Architectural Review Board had presented as to why they were denying the circle driveway. And because of the type of review process that we have, it's a de novo review at City Council level. So in the end, it almost doesn't matter what errors the Architectural Review Board makes or might make. It's up to City Council to do their job and to do it right. I view this as, give us another judge. Another judge might find that our findings meet Topanga, and we had the discretion to deny the driveway. So I would recommend that well, of course, I think we're all in agreement about rescinding the prior decision, that we made a mistake. We didn't, or not made a mistake. We didn't satisfy this judge as to our findings and the facts which supported our findings. And so I would like to see us redo the hearing and do it right. And to address concerns about wasting taxpayer money, we've already collected $9,000 from the petitioners for their initial lawsuit and an anti-SLAPP. So we were successful. We have proven that, yes, they don't have winning arguments. And it all depends on the judge and the day that you go to court. So I would feel that we would have a strong case for an appeal, but I will defer to the other counsel to go with a new hearing on this matter and not send it back to the Architectural Review Board.
Are you making a motion, or is that a comment?
No, that's my comment. Okay.
May I suggest that you first entertain a standalone motion regarding rescission?
I'll make a standalone motion that we rescind our decision. Do I have to state the date of that decision?
You don't have to. It's pursuant to court written and court order.
Decision made on October 17, 2017, concerning the circular driveway at 1231 San Carlos Road.
I'll second it.
Okay, a comment or a question, please?
Yes.
When we say stand alone, that means we can still offer the other, or does it have to be a substitute motion?
No.
No, the next motion, presumably if there is to be one, will deal with what to do next after rescinding the action you took.
Good work, Mr. Beck.
All right, Gene?
Councilmember Beck.
Yes.
Councilmember Robinson.
Yes.
Councilmember Tay.
Yes.
Mayor Pro Tem Chandler.
Yes.
Mayor Villado.
Yes. Okay, that passes 5-0.
I'll make a second, follow-up motion that now that the decision's been rescinded, that we, the city council, set a new city council public hearing on this matter. In other words, we don't send it to the ARB, we don't send it to the planning commission, we set a new hearing date at the city council level.
Do we have a second?
I'll second that one.
Okay, and I'll just add another comment before we go to vote on this, that, again, you know, I find that the architectural review boards have saved the city of Arcadia thousands of dollars, and this case was to support those architectural review board members who volunteer hundreds of hours each year, saving us from having to hire at least 5 employees that would have had to work the counter at our Development Services Department to review all the plans that come through, from everything from solar panels on the roof, to landscape, to, you know, changing out windows, to remodel, rebuild, add on, and that has been invaluable to this city. And I don't appreciate the comments of Mayor Pro Tem Chandler saying that, you know, the architectural review boards are costing us money.
Thank you. I'd like to make a substitute motion, Madam Mayor. That substitute motion will be to rescind our decision of the City Council and adopt the Planning Commission's decision with no opportunity to appeal, and put this to bed. And I
I'm not
disagree.
sure you can make that motion.
Yes, I can.
It's to rescind. We've already rescinded.
Yeah, wait a minute, the first half of the motion we've already done.
Oh, okay.
So
Well, then
you're,
the second step would be that we adopt the Planning Commission's decision on this action and not hold another public hearing by the council.
I believe that's an appropriate substitute motion.
And just to be clear, you're incorporating the findings and facts that the Planning Commission ascertained as the city council's facts and findings.
That's correct.
Yes. Yeah,
And-
their decision.
Do I have a second to the substitute?
Second.
Councilmember Tay, seconds.
We didn't know.
Do we have any other discussion? Seeing none. Jean, vote
Okay.
No, we're voting
on his
Substitute
substitute.
motion goes first.
Mayor Pro Tem Chandler.
Yes.
Councilmember Tay.
Yes.
Councilmember Amundson.
No.
Councilmember Beck.
No.
Mayor Villado.
No. Going then to the original,
I heard the original motion, did it have a second?
yes,
Yes.
Councilmember.
All right, could I suggest that the motion incorporate a proposed date, and I would ask staff whether July 16 or August 6 would be workable?
We have a council member out on July 16th, so I wouldn't recommend we do it that night, so I would do the first or second meeting in August.
August 6th? Everybody's planning on being here? Make sure.
Crosby.
Oh, yeah.
For Roger's birthday?
No.
The 5th.
Oh.
And-
The 5th.
Can we ask Mr. Crosby? and his
Yes, by
attorney?
all means, or his representative.
Maybe the attorney,
That's the first
For Mr.
available, is that?
August 6th? Okay, no, we're just asking, is that
the
date
date
good?
available?
That date available.
Okay.
So if that could be, I'm sorry, if that could be made part of the motion, I would recommend that, if you're comfortable including that.
I am.
Mr.
Now that we-
Amundson?
What?
We were ensuring that he seconded the amendment as well.
Yeah.
He did.
Now that we have Mr. Crosby apparently and his counsel saying, not agreeing to anything, but that August 6th is an open date for them, I would make the motion that we set a new hearing, new city council public hearing on this matter for August 6th, 2019 at 7 o'clock.
Do you still need Councilmember Amundson to second that?
We do, yes.
Second that, yes.
Okay.
Okay. Jean, the vote?
Okay. Councilmember Beck.
Yes.
Councilmember Amundson.
Yes.
Councilmember Tay.
No.
Mayor Pro Tem Chandler,
Just for the spirit of the law, no.
Mayor Villado.
For the spirit of the law, yes. Thank you. The motion carries
Funny, but
3-2.
one thing I wanted to correct that I think the ARBs have saved hundreds of thousands of dollars for the city for all the work they do. Let's put aside this Crosby case because there's a disagreement, but they do a lot of work that is unsung and save the city hundreds of thousands.
I got to adjourn this meeting. I'm
Turn
like,
it quick before you start me up.
sorry. Okay, we're done. No. This meeting is, what am I doing? City Council will adjourn this meeting to Tuesday, July 16th, 2019, 6 PM, City Council Conference Room.